Well, you know, I've been thinking about that, Marcus, and I'm still thinking. I know politicians are supposed to know what they think right away, but one of the arguments we've had in the legislature has been over the idea of regulation, that charter schools are supposed to be nimble, they're supposed to be innovative, and that we don't want to have overburdening regulations going to slow the pace of that. And that's a reasonable argument. I'm not in favor of having a lot of government regulation. But because of the case, I've started thinking about it a little bit differently. I started thinking about how we approach this a little bit differently. You know, rather than force of law regulation, let's call it Mother May I regulation, where you have to get permission from the government. Maybe we ought to take a page out of the private sector book and act as a purchaser of services. And here's what I mean by that. I was talking with a guy who has a manufacturing company up in northern Ohio, and he makes precision parts that he sells to a major multinational manufacturer. Names you would know if I told them to you. And the major, he doesn't own his own tooling on his factory floor. The major global corporation owns the tooling. And they have people that come in and you know, look over his shoulder, so to speak. They are involved in his management of his supply chains. Why is that? Because they've got this huge $1 billion, you know, plant that's using his parts. And so if he ends up having a supply chain problem, a labor problem, if there's an issue with the utility infrastructures, whatever it is, and he goes down and the flow of parts stops, this $1 billion, you know, installation suddenly has to lay everybody off and close down, and then the big company loses all this money. So not because of force, not because of law, but because these guys want to do business with the big multinational corporation, they do it their way. And so things that would otherwise seem to be kind of invasive. What do you mean you want to talk to my suppliers? You know, what do you mean you want to be on my shop floor? Suddenly becomes acceptable because my friend is making a lot of money doing business with these folks. Well, the same thing happens here. You know, this is excuse me. The same thing happens here. This is a buyer's market. We're acting like it's a seller's market. We have new schools that open up every year in Ohio, and we have some schools that fail. It's a dynamic marketplace. So as somebody that's spending $1 billion to purchase educational services, I think the state's in a position not to necessarily use Mother May I regulation, but to identify the things that are important to us to kind of push our vendors, which is what they are, they're selling to us, in the direction that we're confident that we're going to have sustainability and good outcomes. It's the way business is done. If you want to build a new showroom for your car dealership, Detroit's going to want to sign off on it. You can't go out and do a Petticoat Junction theme. If you want to borrow money and have a line of credit from the bank's going to have auditors that are going to come to look at your books. They're going to want to check your inventory if that's part of the collateral. They're going to have people that are going in and conduct inventory, make sure it's there. So it seems to me that the state could wake up and recognize that it can act as other businesses do when they're purchasing large amounts of goods or services, and specify favorable terms. I think we need to drive a better deal for the state.
Can that be done without a change in law?
Well, I think maybe the way to do it, because right now the negotiations happen between the school and the operator, right? That's the contract. So those are unequal. That's unequal bargaining. That's like your teenage kid at 16 going out and negotiating a new car purchase. He's going to get hosed, right? He's just not up to to dealing with a big auto dealer. So recognizing that it's the state and not the school that's purchasing these services, I think you could have a statute, and we already do have a statute, it just could be expanded, that says these are the elements that need to be in place in a contract between a school board and an operator. And House Bill 2 puts a couple of additional requirements in that statute as well. But if we start thinking about this not so much as a matter of having hobnailed government inspectors tramping through the school hallways, and start thinking about it instead of managing the purchase of this large amount of services and on favorable business terms, I think the equation changes a little bit, even though our goals may be coterminous, same, equal.
So are you saying you would support some kind of provision in House Bill 2 that would say contracts shall be written so that the equipment is owned by the school board and not the operator?
Yeah, and I'm not for destroying existing contracts. I think we need to recognize that the Constitution protects existing contracts. It's called the Impairment Contracts Clause. But who's got a pen? Anybody have a pen? So when you have one of these contracts, you're buying a bundle of services, okay? And let's think of this in time. 2, 3, 4, 5, 6, 7, 8, 9, 10. This is years, okay? So we've got a 5-year contract. I'm going to hire XYZ Corp for 5 years to give me a turnkey operation. I give them 95% of my money. They give me books, teachers, school lunches, janitors, everything I could possibly need. Okay, so 5 years, here's your teachers, and if we don't go past 5 years, then the teachers, we're done, right? Because teachers get hired by the year. Janitors the same way, you're not going to have those. But desks, you can use desks for 10 years, right? So they go out here, even though the contract might stop right there at 5 years. And how about textbooks? I don't know how long a textbook works. I was frankly surprised they still have textbooks, because it seems like everything's on a computer, right? But apparently they still have textbooks. Let's say it's a 7-year lifespan. I certainly had 7-year-old textbooks when I was in school. So what we've got now is a 5-year contract here, right? But we've got this residual value out here. So if I'm negotiating this contract, just, Dave Yost Charter School with XYZ Management Company, this looks like value that the school owes back to me if they want to keep this, right? Now, the way the contracts are written, that's kind of a liquidated damages clause, that if you go away, we get to keep all the stuff. And people have rightly pointed out, I think, that that's really an odd business arrangement. I'm not even sure, with the new fiduciary duty language, that you could even write the contract where you get to keep this stuff in the future. A contract that's written in 2016, I'm not sure you can even do that. But I would support it if the legislature were to add something to another bill. I don't think there's going to be new stuff in House Bill 2 unless you guys are hearing differently.
Just to continue along those
Yeah.
lines, do you think, I realize that the court upheld the existing contracts, but do you think that a charter school that is negotiating a contract tomorrow would even consider such a deal in the first place? And number two, as part of an audit, would you retroactively question them if they did agree to such a deal?
I might, I don't know. That's something that, we are working through with our legal staff on what we should and shouldn't be doing here. But as the first thing, I don't think a charter school should enter into something like that. I don't think it's a good deal for the school or the taxpayers that are funding it. And two, I question whether it would even be enforceable if there were a contract dispute after the decision.
Even though the court said that such contracts could be upheld.
It said that contract was going to be upheld.
That you don't think that would apply to similar contracts in a similar situation?
After that decision, I have serious questions whether that would be an enforceable term.
There was one justice who said the contract should be upheld, but there is not a fiduciary duty, correct?
Yeah, I think that, I'm not going to get, I guess there was, there might have been two. I think maybe French and Kennedy said that they didn't agree with that. The fiduciary duty majority was O'Neill, Wise, O'Connor, and Lanzinger.